Welcome to Black History Matters 2022, presented by the National Abolition Hall of Fame and Museum, also known as NAHOF, located in Peterborough, New York. Black History Matters is an educational series that seeks to highlight historical events in the Black American experience. This series consists of 28 videos that NAHOF will release daily through the month of February 2022. Videos are viewable on NAHOF's website. The mission of the National Abolition Hall of Fame and Museum is to honor anti-slavery abolitionists, their work to end slavery and the legacy of that struggle, and strive to complete the second and ongoing abolition, the moral conviction to end racism. This program was funded in part by Humanities New York, with support from the National Endowment for the Humanities. Any views, findings, conclusions, or recommendations expressed in this program do not necessarily represent those of the National Endowment for the Humanities. It is now my pleasure to introduce today's presenter, Thomas Hogle. Dr. Hogle is a professor of social science at SUNY Morrisville in Morrisville, New York. Dr. Hogle has a BA from SUNY Oswego, an MA from SUNY Plattsburgh, and a Ph.D. from the University of Colorado. Dr. Hogle served in the United States Army from 1966 through 1969, in which he was in the Mekong Delta in Vietnam from 1967 through 1968, in the 9th Infantry Division, and where he received the Combat Infantry Badge. Dr. Hogle was born in Washington, D.C., where his parents met in the Army taking care of General John J. Pershing of the American Expeditionary Forces at the Walter Reed Hospital in Washington, D.C. Dr. Hogle is the oldest of 12 children and was raised in Syracuse and Manoa, New York. I'd like to now invite Dr. Hogle to begin his presentation.
Good afternoon, ladies and gentlemen. My name is Dr. John Thomas Hogle, and today I will talk about the 14th Amendment to the Constitution. First of all, I will read the amendment, and since I'm going to make the point that this is the bulwark of American liberties before the state and federal government, I better read it. 14th Amendment, Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 2, representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof is denied to any of the male inhabitants of such state being 21 years of age and citizens of the United States, or in any way abridged except for participation in rebellion or other crime, the basis of representation therein shall be reduced in proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. Section 3, no person shall be a senator or a representative in Congress or an elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or a judicial officer of any state, so to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof, but Congress may, by a vote of 2/3 of each house, remove such disability. Section 4, the validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for service in suppressing insurrection or rebellion, shall not be questioned, but neither the United States nor any state shall assume or pay any debt or obligation incurred in aid or insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave by all such debts, obligations, and claims shall be held illegal and void. The Congress shall have power to enforce by appropriate legislation the provisions of this article. The 14th Amendment was a part of Reconstruction. It concerned blacks, freedmen as they were called at the time. It was the Second Amendment to the 3 Reconstruction Amendments. The 13th, which ended slavery, the 14th, which we're going to talk about today, and the 15th, which allowed black freedmen to vote. Ironically, the 14th Amendment is very close to the exact wording of the Northwest Ordinance passed before the Constitution of the United States had been ratified, 1787. And the Northwest Ordinance forbid slavery above the Ohio River. So we had a restriction on slavery before we had the Constitution of the United States, which wasn't ratified until the summer of 1788. And almost 80 years later, the 14th Amendment is proposed to cover much of the same ground as the Northwest Ordinance. Now, slavery has always been a sleeping giant under the table. It was of our nation. It was there in the Constitutional Convention in the summer of 1787. There was a 3/5 amendment, that the South demanded, and it allowed their slaves, although they were slaves and considered chattel under the law, they should have 3/5 of their number counted as population. 100,000 white people would be, if the determination was every 20,000 citizens would have one representative in the House of Representatives. Well, then South Carolina, for example, would have 5 members of the House of Representatives. But since they also had 100,000 slaves, 3/5 of that would be 60,000. And therefore they would gain 3 extra members of the House of Representatives. And more importantly, the Electoral College by which we elect our president and vice president is determined by a state's 2 senators plus the amount of members of the House of Representatives. So before the Civil War, as the slave states came into the Union, the slave confederation, the slave power, as abolitionists called it, had over 45 electoral votes, more electoral votes based on slaves in the South than the state of New York, the Empire State, had. Consequently, we see a history of mostly Southern slave-holding presidents. President Washington, President Jefferson, President Madison, President Monroe, President Andrew Jackson, John Tyler. The list is a long one. The Southern section held a majority of political power in the Congress for the first 80 years of the United States of America. Now, in the 18th century, many slaveholders, after fighting a war for liberty, were a bit ashamed of slavery. But as Jefferson argued and others, it was a necessary evil. They were plantation farmers. They depended on their livelihood to keep a roof over their heads, to educate their children and to take care of their families. They depended on the work of slaves. Now, at the time of the Constitutional Convention, it was considered by a lot of people that slavery was a dying institution. Slavery was being rapidly removed from the North, and even in the border states, Delaware, Maryland, Kentucky, slavery was slowing down. Over 100,000 slaves have been emancipated, manumission, in the 1780s and the 1790s. So the wish was that it would go away. Unfortunately, the Industrial Revolution begun in England put an end to that. by the use of an improved steam engine used by James Watt in the 1760s, the textile industry was transformed. It was led by England. They had water, they had coal. And steam, you got coal, plenty of water, plenty of rivers. You can create power, and that you can have machine power replacing human power. And now we have the traditional industry of England, which is textiles, cotton, and especially wool, and especially cotton. And in 1793, we have the cotton gin. Eli Whitney, a northern man visiting a South Carolina plantation, saw a boy slave laboriously removing by hand all the many seeds in cotton that made it a hard crop to produce exportable quantities. But his machine, cotton gin, if you will, by placing the iron strips very close together, and using a hook-like device that pushed the cotton through, you collected the seeds and you mathematically increased the ginning of the cotton. And cotton had fibers that were woven farther apart than wool. Wool gets wet, it loses the ability to maintain heat. Cotton is much better. It allows evaporation, and cotton grew and grew and grew. And in the South, we have the black zone, which which stretches from South Carolina all the way through to East Texas, where we have 200 days of frost-free weather every year. It's a loamy soil, and it is excellent for cotton. So we see a steady expansion of the South from South Carolina, North Carolina, Georgia, into Alabama, Mississippi, Louisiana, Missouri, Texas, and cotton is king. 60% of the export of the United States were in cotton by the beginning of the Civil War. Now the South turns and says that slavery is a positive good. We are the masters, the Christian masters. The best state that African Americans can be in is in chattel slavery. We protect them when they are sick. We feed, we clothe them, we give them a place to live when they're too old to work. We provide them with Christianity, and otherwise they will be barbarous. They will be led by their passions, drinking, stealing, fornicating, and therefore we as the masters are best equipped, and this is the best life for them. This is at the same time that an abolitionist movement in the North was decrying slavery as a sin and slaveholders as sinners. And the abolitionist movement was a fringe movement, but it was growing in power. And by the 1840s, they coined a phrase, the slave power. They said, our government is not a free government. It is dominated by the slave power in the Senate, in the presidency, able to stop any legislation that entitles Americans to all their freedoms. Now, the Missouri Compromise, when Missouri, which is below the Ohio River, banned by the Northwest Ordinance of allowing slavery, demanded to be let in as a slave state. And if it didn't, there were hotheads in the South who were already talking about leaving. They said, we voluntarily join the Union. We most certainly can voluntarily leave the Union. Henry Clay came up with a compromise. Maine wanted to break off from Massachusetts and be brought in as a free state, thereby evening the slave and free at 11 apiece. And we have the Missouri Compromise in 1820 and 1821. Civil War averted. The only area that was still open to slavery after the Missouri Compromise was a section called Arkansas, which will duly be entered into the Union when it applies. But the rest except for some land up to the Pacific Ocean in the Oregon Territory, was controlled by Spain and then Mexico after the Mexican Revolution. But we had no territory to worry about slavery. So it got us through. The Compromise of 1820-21 lasted until when President James K. Polk got Texas annexed in 1845, he had made a campaign promise that he would bring territory into the United States. And he sent troops under General Zachary Taylor to patrol the Nueces River. The Rio Grande River, which is 100 miles south of the Nueces River, which had been the longtime boundary of Tejana, of Texas. And the Mexican troops crossed the Rio Grande, attacked Zachary Taylor's troops, which by their lights was Mexican territory. As soon as the message was received by James K. Polk, I believe there were 8 Americans killed. He said, "American blood has been shed on American soil." And he declared war in April of 1846. Now, for less than 2 years, the Americans were usually outnumbered, but always successful in fighting the Mexicans. They took Mexico City in September of 1847, and then there was no country, no organized government to surrender. Finally, in 1848, the Mexicans in a suburb outside of Mexico City signed a peace treaty, which literally took the top half of Mexico and joined it to the United States. Okay, it's called the Mexican Cession. Now we had a new problem. There were large amounts of territory. I believe 800,000 acres. Will there be slavery? Will there be free men only? And both sides dig in their heels. In 1850, a compromise is made, the Compromise of 1850, which gave California the right to come in as a free state, even though it was below the boundary of Missouri. And it also gave slavers the right to send slave catchers up to the north to recover their runaway slaves. It led to incidents. It led to sharpening division between the two regions. In 1854, we have Stephen Douglas, senator from Illinois. He proposes to build a railroad to San Francisco from Chicago, his native state of Illinois, major city. In order to get Southern support, he had to put in the Kansas-Nebraska Act, popular sovereignty, squatter sovereignty, if you will. No decision will be made on slavery until a territory seeks to be admitted to the Union as a state. Then the people will be able to vote. And this starts battle, guerrilla warfare, burning of Lawrence. It's called Bleeding Kansas, and they have an unofficial war there. And it's all about slavery. Is Kansas going to be a slave state or not? In 1857, in a Dred Scott decision, the Supreme Court ruled that a slave who had been owned by an American Army doctor and had resided in Illinois and Minnesota territory, he sued to say that he was free because he lived in free territory. Well, a majority vote of 6-3, with the majority of the justices being Southerners, they ruled that Black people are not citizens and Black people have no rights which white people have to observe. It was crushing defeat for the abolitionists, but by now they have a party. The Republican Party is dedicated to free soil, free men, and no slavery in the territories. They don't say they're going to violate the Dred Scott decision. They say they will get into power, they will appoint Supreme Court justices, and eventually they will overrule the Dred Scott decision. 1858, Stephen Douglas had to fight for his senatorialship against Abraham Lincoln, who was a Republican and firmly resolved that slavery should be denied in the territories. By 1860, the fact that Lincoln lost in Illinois, still the coverage had been very good with telegraphs. American voters all over the country could hear his speeches, could hear his debates, the Lincoln-Douglas debates. They could hear his moderate profile on slavery. He didn't want to remove it in the states that were admitted and had it, but he was adamant that he would not let it expand. Now, in 1860, the Republican campaign is held in Chicago, and Lincoln wins the nomination, and the Democratic Party, the last party that had voters in both the North and the South, splits asunder. The Northern Democrats are led by Stephen Douglas. There is a border state party that nominates John Bell, and there are Southern Democrats. So we have the pro-slavery Southern Democrats, pro-slavery in the territories, under the vice president of James Buchanan. Lincoln wins. He wins the election. Immediately, South Carolina leaves the Union in December 20th of 1861. 7 states leave by the time that the Confederate States of America are founded. And then when Lincoln tries to supply Fort Sumter and Charleston Harbor, the Confederate States opened a bombardment. We are in a state of war as of April 1861. By April of 1865, the tremendous advantage in of manufacturing, of money, of men, and women too, the North has subdued the South. Robert E. Lee surrenders at Appomattox Courthouse on April 9th. Lincoln has been reelected president in 1864, and he is appointed a Southern loyal Democrat, okay, called a war Democrat. Andrew Johnson of Tennessee, a Southerner, and Lincoln wanted to bring soldiers in. Over 200,000 Black men had served in the Union Army and in the Union Navy. Almost 40,000 of them had died. And he wanted them to be able to vote. He had emancipated the slaves in the South, the Emancipation Proclamation, but it really didn't emancipate slaves, because the only ones that were free under the Emancipation Proclamation were controlled by the Southerners. But it meant that Blacks ran to the Union forces to get away. The promise of freedom was there. Now, Lincoln wants to get slavery ended. He doesn't want the Emancipation Proclamation to be his only legal device for freeing the slaves, because it's a war measure. It could be overturned by Congress. He wants an amendment to the Constitution. He manages to get the 13th Amendment with a 2/3 majority. Remember, the South is still in subjugation. They're not sending any representatives. They can't overturn the 13th Amendment. In December of 1865, after his death on April 15th, the 13th Amendment ending slavery is admitted to the Constitution with a 2/3 vote of the states and a 2/3 vote of the House and Senate and a 3/4 vote of the states. Now, the next question is going to come about because of the adamant refusal to accept French enfranchisement of Blacks by Andrew Johnson, who at heart is a racist Southern supremacist from Tennessee. He allows Southern states to, if they will accept the United States, if they will repudiate the Confederate debt, if they will not allow any officers or legislatures above the rank of colonel to hold office or vote, he will let them be admitted, reconstructed. Well, we got the vice president of the Confederate States is elected to his old seat as a senator of Georgia. Other Confederate loyalists are elected as governors and legislatures. They were already lynching black men in uniform, and they were harassing and terrorizing Northern and Southern whites who defended the government, and they showed no remorse. And what happened, only Congress can decide who sits in office. And when all these unregenerate Confederates arrived at the Capitol in December of 1865, they were refused admission. They did not get in. The Republican Party still had an overwhelming number in the House and the Senate. Now, Johnson faced a Civil Rights Act that gave specific rights for freedmen. He vetoed it. The Republicans, now even the most moderate Republicans, could see that the South was unregenerate. They were not sorry. They were rebels still. And we had a president who seemed to be siding with the rebels at every turn, former rebels at every turn. So they decided they need a 14th Amendment. They need an amendment to the Congress. And in 1866, they got that amendment passed. The 14th Amendment was very important. What it said is that you could not deny the rights, the privileges and immunities of citizenship except by recourse to law. All citizens have certain rights, privileges, and immunities, and you can only take them away by being convicted at a trial or judicially. It also says that the United States is the arbiter, not the states, of these issues, that Congress will maintain the right to implement the 14th Amendment. So now we've got freedmen are citizens, their children will be citizens, and you cannot simply take away their rights, privileges, and immunities. It's called equal protection of the law. Now, all the Southern Confederate states have to ratify the 13th Amendment before they're admitted to full participation in the United States government, and the 14th Amendment, and eventually the 15th, which will be passed in 1870. The 14th Amendment is ratified in 1868. Let me say this, Andrew Johnson has been impeached but not removed in the spring of 1868. In November of 1868, Ulysses S. Grant, the victor of the implementation of victory in the Civil War, is elected president. And a startling conclusion is reached by the Republicans. Grant beat Horatio Seymour, governor of New York, by 300,000 votes. 450,000 freedmen voted in the South. It's becoming very clear that without the freedmen's vote, without the black male voters, the Republicans were going to lose their hold on presidential and congressional power. So that only gives them a more enthusiastic need for a 14th Amendment. Without the South, they will become lacking in presidential power, at least possibly. Now, the problem with the 14th Amendment is that it was ignored. The Supreme Court, you can have legislation, you can have an amendment, but if the Supreme Court won't uphold it, it doesn't mean anything. Let's face it, folks. The Constitution is whatever 5 of 9 Supreme Court justices rule. And in 1873, in the slaughterhouse cases, the Supreme Court ruled that that citizens cannot sue the state. It was about Louisiana and state-sanctioned slaughterhouses, and private slaughterhouse owners protested that their privileges and immunities were denied, but the court ruled that they couldn't bring suit against their state, which is contrary to the 14th Amendment. So what are you going to do? you lost 5-4. We also have in the slaughterhouse cases, wait a minute, civil rights cases that appeared in 1883, the court again said that you can't sue the states by a denial, saying that they denied your privileges and immunities. In 1886, they went completely around, and they argued in Santa Clara County versus Southern Pacific Railroad that the railroad is a person. Corporations are people, and you cannot take away their privileges and immunities. It's a violation of the 14th Amendment. So we have the 14th Amendment specifically aimed at freedmen, and birthright citizenship is now a protection of corporations. And why do we have that? Well, because the Supreme Court had a lot of lawyers who had made their living in the railroad industry. And so they took the 14th Amendment, twisted it out of shape, and gave it protection to big railroads, big corporations. Frankly, ridiculous on its face, yet that is the law of the land. Now, what does happen, as soon as Union troops left the South in 1877, the Compromise of 1877, when a Republican won the election in a very close election that had to be decided by a joint House of Representatives Senate committee. They gave all 8-7. The Republicans outnumbered the Democrats. They gave all the disputed electoral votes to the Republican, and President Hayes was elected, and he pulled troops out of the South. As soon as the federal troops were gone, the South began to tear down the Reconstruction governments. They initialed Jim Crow laws, segregation in education, in travel, in accommodations. They disenfranchised Black men in between 1880 and 1910 by having poll taxes. You had to pay to use the polling booth, the literacy clauses. You would be told by white members of the southern states that you were illiterate, even if you happen to be a college graduate. If you actually were an illiterate white man, they would just read it to you, and whatever you said, they'd give it to you. And my favorite, the grandfather clause. No one could vote in most southern states, unless your grandfather voted in the 1860 election, which would be hard to do because slavery was in full existence then. Jim Crow leads to lynch law. We were losing 150 men in border states and southern states every year from the 1880s up until the 1930s. There was never a federal law against lynching because the Southerners would not accept the law. They would stymie it. But the Supreme Court turned a corner in the 20th century. They began to say that the 14th Amendment incorporated the Bill of Rights against the states. And this gives the citizens protection against the states. The Bill of Rights was only supposed to protect citizens from the federal government. Barron versus Baltimore in 1833, John Marshall and his court said this doesn't protect you from the state of Maryland. The Bill of Rights only protect you from the federal government. Therefore, states could do what they wanted. Now we see the states being included, and we get some of our most famous decisions. We get the Supreme Court case in 1965 in Connecticut that allowed birth control information not to be considered pornography, and that married couples, anybody, can receive such information. We get Roe versus Wade in 1973, which gives the right to privacy, and it allows women to terminate a pregnancy within the first trimester of their 9-month pregnancy. We get the Obergefell position, I believe in 2013, which allows gays, couples and gay citizens the full rights of citizenship and the right to be married. So The incorporation is not total, but most of the Bill of Rights have been incorporated under incorporation. We're still arguing about the right to privacy, which is unstated in the Constitution, but and is a strong article of contention today. But today, the bulwark of the 14th Amendment protections for American citizens are in the 14th Amendment and incorporated into our whole government. And I want to remind you what Eric Foner said. He said the revolution, he calls it the second foundation, reconstruction, is ongoing. It ebbs and flows. It is never over. Thank you very much.
Thank you, Dr. Hogle, for your contribution of this presentation. If you are interested in learning more about this topic, NAHOF has provided a reference list of sources to learn more about it in the video description box. Please help us by completing a brief survey available at the link on your screen and also in the video description box. Your feedback will help NAHOF receive funding and help plan future projects. Additionally, please contact NAHOF with any questions and if you're interested in learning more about the organization and its work. Once again, thank you, Dr. Hogle, for donating your time and contributing to this program. And thank you, the audience, for joining us on this educational journey, Black History Matters. We hope to see you at our next presentation.